Right, so today in this lecture we're going to look at the rights of criminal defendants, and notice here that I've grouped together the 4th, 5th, 6th, and 8th. The 7th and the right to trial isn't included here. Typically we don't see many cases about that, or so we're looking at cases and amendments that have been incorporated. So all of these have the commonality of dealing with people's rights, specifically when they've been accused of a crime. And if you notice here, the procedural guarantees. So are the processes being followed? And we'll look at the differences between each of these amendments. So if there's a couple of justices you need to know, one of them being Marbury versus Madison, you should know John Marshall. You should also know Earl Warren. So Earl Warren is considered to be the most activist of justices. So by activist, it means that he sees the Constitution as a growing document. And so when we see this, lots of the cases in the 1960s are all attributed to the Warren Court. So again, when we look at a court and a time period, we refer to that time period by the last name of the justice. So those cases like Miranda and Gideon and Matt v. Ohio are all under the Warren Court. So here's the text of the 4th Amendment. And notice here that it talks about securing their persons, houses, papers, and effects. And so this is constantly being interpreted or reinterpreted to understand what that means. So what exactly does your papers mean? And so we'll look at some examples, and lots of the court cases you've looked at have dealt with this. All right, so the 4th Amendment here to deny the government was intended to limit the power of law enforcement. So in other words, they can't be arbitrary in their searches. And again, this was a reaction to what's happening in colonial England. But there have been what we call good faith exceptions, or times when the courts have ruled that it's okay for them not to have a warrant. And I think the examples that I've given you are times of duress, so something like the Boston Marathon, they wouldn't be required at that time. Or if we can say that they would have, in good faith, would have found that information anyways. So notice that they have interpreted the 4th to allow you to search the person arrested, things in plain view of the accused. This could be things on them, this could be their car, or things that they could touch in their immediate control. So a couple of different things here. I don't know that you'd necessarily ask that, but just to give you sort of an idea of the scope of the 4th Amendment, they have what's called the knock and announce, and we see this in crime shows, right? Police are here, we have a warrant, so that you know that the intent of the police at your door. Again, we're trying to limit abuses by the police. You'll also notice they talk about thermal imaging. What's come up lately have been things like drones, and I think it's only a matter of time before there's a case on that. What are the limits there? You also notice that in 2006, and this again sort of comes up when we talk about Matt v. Ohio, if someone objects, in the case here in 2006, the roommate said that person's not home, and then the other one said, well, I guess you can come in. So what if someone objects, and the police, because normally if you say you can come in without a warrant, you're okay, but even if someone objects, then they have to wait. All right, so the 4th Amendment's protection against unreasonable search and seizure obviously requires a search warrant. So what happens if an illegal search takes place and the government knows it, right? How should it respond? The 4th Amendment doesn't specifically answer this question. So we have what's called the exclusionary rule. We talked about that eliminates any evidence to conduct illegal searches. The fruit of that searches, so we talked about the fruit of the poison tree, a very famous case of Wong Sung. But again, you have to really show evidence that illegal conduct has been done by law enforcement. And so we can look at some different examples there. You'll see there that below that I have the example of Chandler versus Miller. So search can also relate to search of our bodies. And so something like drug testing, and you'll notice that in the public sector, we typically aren't drug tested. I know there's some types of drugs that are, teachers aren't. But in the private sector, you are administered drug tests because the private companies can decide what they want to do. So I had to before I worked both of my private sector jobs, but not before I started teaching. So kind of thinking about what that means in terms of search and seizure and your rights there. Again, search and seizure says that illegally obtained evidence cannot be used in court, and there's lots of implications for that, and thinking about sort of the technicalities that go around that. All right, so that gets us the 5th Amendment. So if we think about the 5th Amendment at its very basics, right, the Fifth Amendment is our due process rights. And so if we think about due process, we're thinking about our protections from the government and making sure that things are carried out, right? Double jeopardy, self-incrimination. The people under arrest have to be, they have to know their rights, and as it says, they're taking the fifth, you have the right to remain silent if you so desire. So a little bit more here about the Fifth Amendment. And you can go through here, talk about double jeopardy, prevents the national government from denying a person of due rights. You should have also noticed in the book that it talks about what's called the takings clause. So you have to be fairly compensated for things that are taken from you. All of those things fit under the Fifth Amendment. So again, if we go back to the Fourth and Fifth, where do we see overlaps of these? So the police, if we have to look at the rights of criminal defendants, right, we're trying to protect them from abuses. And so if we think about the overlap here, we can also think about their content search and what rights you have in terms of that. And the case that you see here is the case of Weeks versus Ohio. A pretty famous case, right? Or Weeks versus United States, sorry. In 1916, the court barred the use of federal prosecution of illegally seized evidence. So one of the main privacy rights that you have is against arbitrary intrusion by the police. So this case of Weeks versus the U.S. Is at the core of the Fourth Amendment. And so that's a pretty important case because it does ban that illegally obtained evidence. We talked a lot about Map v. Ohio. There's some great videos out there as you look at the right of Map v. Ohio. So again, if you don't have a warrant and you find the warrants for something else, can that information be used in court in this illegal case? And again, thinking about what you saw in that video, and those of you that didn't see the video, you can also look on the page to understand the fourth. But Wolf versus Colorado, Map versus Ohio, and Aguilar versus Texas all deal with the idea of preventing unreasonable search and seizure. All right, so the last piece here is what's a good faith exception. So if we look at the good faith exception, right, we look at the argument that the exclusionary rules that while it may be an effective way of deterring unreasonable search and seizures, it has no such effect when the police have acted in good faith but simply made a mistake. So there's something wrong on the warrant. And maybe it was a secretarial thing. So the Supreme Court has ruled that if the police acted in good faith, or the idea that they inevitably, in other words, through the normal process of an investigation, they would have found information, then the inevitable discovery would have allowed it to go on. All right, so this gets us to the Sixth Amendment. At the basic level, the Sixth Amendment is the right to counsel. And again, if we group all of these things together, our fundamental rights, the Fourth, Fifth, Sixth, and Eighth as they come together. So the Sixth Amendment was incorporated in 1948 in the case, in what we call the Oliver case. You don't necessarily need to know that, but you should understand the basics of the Sixth Amendment, speedy public trials, impartial juries, and most importantly, the right to counsel that we get in Gideon versus Wainwright. So the right to counsel comes in 1963 by the fact that it's now applied to the states. And again, thinking about, and we have to understand our incorporation and knowing that that now applies to the states. Remember, the Gideon case was he couldn't afford a lawyer, and now it's applied to the states. So when people are facing criminal prosecution, they have the right to confront witnesses, they have a right to a speedy trial, and the right to a lawyer. Really only a small percentage of criminal cases are decided by jury trials. Some involve bench trials, but the vast majority actually end in what we call plea bargaining, so they don't even get to the actual court, which is why a lawyer is so important. So again, you can look at some different things here about the Sixth Amendment. Again, thinking about the rights that they have, the impartiality of a jury. So this speaks to the fact that the jury should mimic the population. And so there's a lot of interesting things here in jury selection, right? And the kinds of questions they ask them. Do they already have prior involvement in this topic? Right? If you're trying a case against a man, it would probably be unfair to have a jury of all women. And so the case here in 1986 looks at the fact that you're supposed to be getting a jury that doesn't come with prior knowledge. Really hard and famous cases, especially with media coverage. So this gets us into our final topic here, related to the rights of criminal defendants, and that has to do with cruel and unusual punishment. We spent a lot of time on this. Again, the cartoon here speaks to states that have the strongest use of the death penalty, and Texas being that state. All right, so the 8th Amendment. If we look at the 8th Amendment, again, it's included here, right, as a right of those who have been suspected of a crime, in other words, your fundamental rights. So the 8th Amendment prohibits cruel and unusual punishment, and you notice here excessive bail could also be into that. There's lots of modern cases about the types of drugs, the types of injections, and whether those are considered to be cruel. The best example I can give you is the case in Kentucky about the process that was deemed too cruel for animals. So some major death penalty cases, and this is really, really key to understand. The Supreme Court ends capital punishment in 1972, saying it was done in an arbitrary manner. And then if you notice, it brings it back in 1976. So when we look at court cases here for the death penalty, we always look at them after 1976 and what's been the ruling. If you notice in 1987, there was the case that argued that the death penalty essentially was racist, right? That it was unfairly burdening African Americans, but they overruled that, or they let that stay, and they said it was not. And the other see in 2006, this is where we start seeing DNA evidence and where people are wrongly convicted, and that's the case of House versus Bell. All right, this is something we went over in class, right? We can look at different rules in different states for your age, right? Your mental capacity. And again, this is something really interesting. You can read up on this in terms of how each state does it. So just a quick review, and again, we talked about this in class, different states and their different methods. This one reviews the methods used in different states. And again, this is always changing. So it's actually kind of hard to keep up sometimes. All right, and our final amendment here, because we've already talked about the 10th Amendment, we talked about federalism, is the 9th Amendment. The 9th Amendment provides a foundation for reading a right to privacy into the Constitution. It's a pretty interesting history into what the framers thought of individual rights, and so we can look at the 9th Amendment, and again, the right to be left alone. We can look at Federalist number 84. Alexander Hamilton explained why he thought the framers did not include a Bill of Rights in the Constitution, and he gave two pretty big, broad reasons. He first states that the Bill of Rights was unnecessary, and he felt that was valid for two reasons, right? He already said that we had a right of the privilege of habeas corpus. We had no bill of attainder, no ex post facto, no title of nobility, trial by all juries. These are in Article 3, definition and proof. And they also thought it was unnecessary due to the dramatic nature, or the democratic nature, of the Constitution. And he talks about that it's evident that according to the Bill of Rights, they have no application to constitutions, professed founded upon the people and executed by their immediate representatives service. Here in strictness, the people surrender nothing, as they retain everything. They have no need of particular reservations. So he actually thought the Bill of Rights would be dangerous because he thought not all the Bill of Rights would be listed in the Constitution, and if we tried to list them all, we would definitely miss some. So this is where, right, Madison, the father of the Bill of Rights, believed that the Bill of Rights was unnecessary, but he gives a nod to this, right, and he looks at Hamilton's argument about the Bill of Rights and argues that, well, we might not get everything. So he proposed this 9th Amendment. And the 9th Amendment, again, is proposed by Madison to make sure that we didn't miss everything. Sometimes it's called the Forgotten Amendment. There's only one sentence in the Constitution that tells the reader how to interpret the Constitution. It basically states that the reader should not take the listing of rights in the first 8th Amendments to imply that these are the only rights, but that we have more. And so we see that in the 9th Amendment. Most commonly applied with the right to privacy, as the Supreme Court has asserted that the right to privacy exists, particularly in the area of sexual contact. So we see that this is applied to cases like birth control, right to die, homosexuality, and euthanasia. So here we can start with the case of Griswold versus Connecticut in 1965. And it basically deals with the right of married couples to privacy in their sexual conduct, right? They can use the pill if they want. And so we, again, with the case of Griswold versus Connecticut, we see the beginnings of this use of the 9th Amendment and the right to privacy. That gets us to Roe versus Wade. And Roe versus Wade deals with abortion, 1973. It establishes a right to privacy as a basis for women's right to make a choice about an abortion. And again, it divides it into 3 stages, and each stage tells you the rights that you have relative to the woman's rights, relative to the protecting the interest of the state. More modern cases here, we talk about Webster versus reproductive health, and part of that looks at women's rights. And in some cases, we can say that rights of abortion have been chipped away over time, and the right that people have in terms of making that choice. So a few last cases here, Planned Parenthood versus Casey. If we look at this one, we can also see sort of limiting the scope of when things are allowed, specifically sort of, as I said, chipping away at Roe versus Wade. You can look at the Partial Birth Abortion Act. I don't know if you'd necessarily be asked about those, but it does give you a good idea that there have been, it goes sort of up and down in the rights provided through this 9th Amendment to abortion. All right, and the last thing here would be rights for the homosexual population. And so we can look at, this poster here was from a couple of years ago when, and I think it's happened again last year, where students were denied access to things like prom if they came with a same-sex partner. The most famous case of the rights to practice your own sexual conduct, and Bowers versus Hardwick, they upheld the right of the state to prohibit homosexual activity between consulting adults, but it was overturned in Lawrence versus Texas, and this is very, very recent. And so if we think about this, right, we want to think about the fact that it wasn't until 2003 that these laws were restricting the private, non-commercial sexual activity between consenting adults. And that's the real key here, that the idea that you can do whatever you want in your own home. All right, this is an interesting thing because the court just took this up in 2012. And the Defense of Marriage Act had been passed in 1996. In other words, saying marriage is only between a man and a woman. And then in 2012, the court took this up, and they basically argued, and they found that that law was unconstitutional. So this initially started with Vermont passing same-sex unions, and then Massachusetts and the city of San Francisco. And then when the Supreme Court took this on, they basically found that the Defense of Marriage Act, or DOMA as it's referred to, was unconstitutional. So it's interesting to see that just in the time that I've been teaching this class, we have lots of things that have been overturned as it relates to these rights of private sexual acts. Again, you can look at a state-by-state breakdown. This one is from a couple of years ago, 2007, so you can see how much it changed from the one that I showed you in class. And again, here's sort of a look at it over time as we see changes. This was originally before the Supreme Court took this case. Again, if we look here at the cases of Lawrence versus Texas, which laws have anti-sodomy laws? And the last piece here is the right to die. We talked a little bit about states that do allow a right to privacy as it comes to the right to die. We normally associate this with the terminally ill and their right to choose to end their life, and the person helping them not being targeted or prosecuted. So Oregon was the first to do this. We see this in Gonzalez versus Oregon. It's the Attorney General prosecuting. And the court actually upheld Oregon's law. Right now, I think there's only 3 states, maybe 4, that allow this. All right, and the last piece here has to do with civil liberties and what we refer to as sort of protections against terrorism. A lot of this changed after September 11th. The Patriot Act was passed to protect Americans on American soil right after September 2001. The Department of Justice wanted to prevent future attacks, so they passed that act. It played a key part in a leading role in a number of successful operations to protect innocent Americans from terrorism. But while that has been important, what we've seen is that Congress has provided only modest incremental changes in the law. Um, and so we see lots of what some people would call abuses of civil liberties. And if you notice here, when you're locked up, let's say, as for many years people were in Guantanamo, what kinds of protections were provided for them? And even recent data has come out about many of the tortures, and that people in places like Guantanamo were given to try and get them to give information, and did this violate their 8th Amendment?